We have a quorum with the 4 sitting board members present, so I call the meeting to order. First is adopt the agenda. Is there a motion to adopt the agenda? There's a motion to adopt the agenda. Is there any comments, discussion? All in favor? Next is approval of the minutes of the January 10th, 2023 board meeting. Are there corrections to the meeting minutes? Approval of the meeting minutes. Are there any corrections to the meeting minutes? Okay, they stand approved. Which brings us to new business. Election of officers. Clay.
I move that Laura Ballwelber continue as president, Clay Jones continue as treasurer. We elect Walker Flannery as secretary, and we elect John Tuna as vice president.
I prefer it was John Tyler.
It's not two, it's a Tom? How did I not know that?
Any other comments? All in favor? Which brings us then to the bulk of what this meeting is for, it's the policies. Just allow me to state that the board contracted with, is it Muller Graph?
Yeah,
Muller Graph, which provided 3 revised and 1 new policy for the association to bring them in compliance with HB 221137 from last year, as well as other statutes. And then they also suggested a change to the policy for adopting and amending policies. The board has reviewed the policies, and so the very first one that we want to bring up is the covenant enforcement procedure policy. Is there a motion to adopt the policy? All right. We've had a few comments come in through the HOA email. And so for those of you that have given us your comments, thank you. If you have provided comments via the HOA email and wish to make further comments tonight, please do so, but please confine your comments to new comments. So having said that, are there homeowner comments for consideration? Yes.
I have some, yeah. What I'm about to point out, I think is basic, and I'm just pointing them out because I know this is a lot of hard work, and I know that it's hard to be something simple that's straightforward, and anticipate what might be the case in reality. But sometimes ambiguities can be confusing and down the road. So I'm going to raise 3 points about the policy. One is that the way I read it, there's kind of a sequence problem in terms of the contact. What happens is if, let's say, Joel wants to make a complaint against me and if there's an alleged violation of the governing documents, then it goes to the board. If he does it, he does it in writing, whatever he puts in writing, and then what he would do, what the board would do, is determine whether it has sufficient support for an allegation and whether it's public safety problem or not. The next thing that you find in the sequence is that the owner, who would be me, who's the alleged violator, has the option of, first of all, asking for a designated contact other than me. It also has the option for asking for the correspondence to be in another language like Spanish, and even requesting a hearing. So up until now, I don't know that he's done, that he's submitted an allegation in writing to the board. So how do I know? I'll get your first notification of a violation, but how do I know how to make those choices? That I want someone else to be designated and contact, or that I want the correspondence to be done in Spanish as opposed to English. So there's, so far, as the perpetrator of the violation, I don't know that. So that's one question. I can go one by one, or we can go, I'll get them all done, but the second one I have is, regarding the notification that you get and the request for a hearing. I know that if I get, using the same illustration, if I get I get a notice in writing from a first violation from the board, I can request a hearing. And I have to do that hearing, if it's a regular violation, it's within the 30 days of the first 30-day period. And if it's for a public safety issue, then I have that 72 hours to request a hearing to defend myself against this thing, right? That's the whole idea. So what happens to that 72-hour period? Is it in suspension? What happens to the 30-day period? Because let's say the hearing might take 10 days to get the hearing put together to have a hearing. And what happens in the interim? Does the clock keep ticking, or is it held in abeyance until you have the hearing? Because so far, maybe I would defend myself and I will win out in the discussion, and the board would say, this really isn't a violation. So that's another thing I see that's missing, or that might be an issue that some ambiguity will be there. And finally, I had a question, which is, the hearing procedures itself says that there would be a chair, the president of the board, or a committee chair, and then it says designee. Who's the designee? Who could be designated? Is that anybody from the neighborhood? Or who designates that person to be the decision maker or of the hearing? And who can it be? Is it someone that's been elected as part of the board, as part of the board that represents through some election, or is it someone that fits that role of an impartial decision maker? That's a question. I don't have an answer for that. So those are the only three. I do have some confusion over what's to be contained in the content of the notifications, because I see, if you look under the public safety section, it says then there's a C, which says has to contain the time interval, and then D, it says the 72 hours. They're the same. And in the case of the regular violation, it's the same thing as C and E. They're duplication. It's just, it has to contain the time interval for what would take place for curing the violation, and it also then E says you have to have within 30 days you have to cure the violation. So it's like it's a duplication. I don't know if I have wrong. Those are my comments.
You look like you want to say something, John.
Do you want me to try and address those, or
Sure.
would you like to?
No, go ahead.
So as far as how do you know what your options are, when you get the first notice, it's at that point it's an alleged violation or a potential violation. And no one's accusing you of having done something. We're just notifying you that we've been made aware that there is a potential violation. And that letter would tell you about all your options, or it would refer you to the policy where you could look up all your options. And you know, the purpose of the hearing is not for you to defend yourself, it's to perhaps explain some mitigating circumstances or some misunderstanding. So, you know, that's the first step in the process. Does the clock keep ticking when you've requested a hearing? I believe, and maybe someone else can help me with this, I believe that the clock stops ticking and the hearing delays the period until it's conducted. That's what I understand. But I may be...
It doesn't say that.
No, it doesn't say that, but I may be corrected on that. And then your next question is, who is a designee? So this would be a situation where the president or the chair of the committee had some conflict of interest, should we say, so they couldn't chair the hearing. In which case, a designee would be appointed. And I assume that would come from, there would be another owner, not necessarily another member of the board or committee, but another owner who, like you say, met that definition of impartial.
Like I said, I'm just trying, I'm thinking ahead, putting myself in the shoes. If I hope it never happens to me, but if it ever would happen, I would want, those are the kind of things that might trip up the what looks like a very, very well done and a lot of hard work and effort put into the document. And I'm thinking out loud when I'm reading this that, well, what happens if this? And that's on the case of the sequence. You mentioned that it's just an alleged violation, but when you send, when the board would send an alleged violation to me, the clock starts ticking, right?
Yes.
And then, so when do I have the opportunity, knowing that now that I have been alleged violator, when do I have the chance to make those choices about asking for a designated contact? I don't really know who would do that, but it's obviously must be in compliance with the overall policy which you've done. So, I mean, I don't know anybody that would say, okay, you can't talk to me, you have to talk to my wife, or you have to talk to Joel. So anyway, but that's why I asked the question, because so far I wouldn't even have known until I get that alleged violation notification from the board that I'm being accused of violating or being responsible for an alleged violation. So then only then would I know to make those choices that you have outlined before. So, yeah, I'm just.
Yeah, that's right.
Yeah.
Yeah.
Further comments, homeowner comments?
Are you doing these one by one,
Doing what?
the policies? Are you going
Yes.
through them one by one? So we're just on covenant
Agenda
policy?
is.
Okay. Are you going to address any of the emailed questions on your own, or we're trying to save time here, so are you going to respond to any of those?
The board will have a discussion after the homeowners have an opportunity to provide further comments.
Okay. I have a couple questions. On the initial section 3 regarding the neighbor-to-neighbor disputes, that appears to be a change in our policy. It says that this has to be related to something in the governing documents. Is this now going to undo the policy that we had, which is we never ever, in an absolute term, get involved in neighbor-to-neighbor disputes? How would one know when those are occurring.
Can you please,
Want to rephrase that?
no, can you please tell me which section again you're
Section
referring to?
3. Yeah, section 3.
Section 3.
Is that Roman numeral 3 or?
This is on page 3 and then number 3, purpose.
So that's not section, that's section 2. That's not section 3, that's why, it's Roman, by Roman numeral, it'd be section, Roman numeral 2.
I apologize. Page 3, under purpose, the second paragraph at the top. That's Roman numeral 1.
Right, so it
section-
says to the
Section 3.
To the extent that a neighbor-to-neighbor dispute exists that is not a violation of the association's governing documents, the board encourages neighbors to resolve the dispute, da-da-da-da-da.
So the concern here is that, and I know that you react every time I bring up FHA law, but that's where this derives from. And I'm familiar with David Graff's video on the subject, tying it to, it has to be a violation of the governing documents. Section 24 of Article X in our CCRs is about disturbing the peace. And so when you're in the area of civil rights complaints, this is a very vague area. Is there any intention to do clarification in the CCR so that we know when there is or is not something that could be applicable? Because this is vague language within the new policy, but things that would protect protected classes may be behavioral issues.
It involves changing CCRs, that requires a community-wide vote and 2/3 majority to change things, so apparently not.
Apparently not.
Well, we're not changing CCRs here tonight. I mean,
Right.
we don't have that
Correct,
authority.
but is there an intention to look at that going forward? Because this is a really vague section, and I think it would be a good idea to clarify so that we can avoid any disputes.
Well, there's no doubt that our CCRs are in need of updating, just as the bylaws are, but, right now, our immediate concern are these policies.
Relative to the complaint process, so you're talking about a written complaint for homeowners, but a director doesn't have to put their complaint in writing. That seems to create a loophole whereby a homeowner can simply tell a director, hey, I'm aware of this violation, and avoid that requirement for putting it in writing. Similarly, a director then has a privilege beyond all the other homeowners to simply not have to put things in writing. It seems like we're then, only those that don't have a relationship with the director would then be required to do so. It seems better to have a policy that's equal for everybody. If there's going to be a complaint, it should always be in writing. Is that something that you're amenable to amending tonight before passing this policy?
My personal opinion is, writing. The policy also says that the board does not have to investigate verbal or anonymous complaints.
Does not have to,
No.
but can. So for
Correct.
some people, it can go one way, like if you have a personal friendship with the director, you might get treated in one way, and if you don't, well, then you have to put it in writing.
Well,
Which
I'm
opens that
hoping
person
that
up.
we have enough members of the board and enough diversity on the board that we could avoid such issues.
Right, but that's, you're talking about the current seating. 5 years from now, it could be completely different people. So we have to plan for not just your personal intentions, but what could happen. And it seems like this creates a loophole. Why not just have a universal rule? All complaints have to be done in writing, including those that are sitting board members. And if the board member is the sole party making the complaint, they probably have a personal interest that's a conflict of interest and probably need to recuse from the process. Shouldn't have a vote.
Well, that's
in-
not necessarily true, Andy. I think as board members, I think we do owe a duty to the community that when we see an obvious violation of any of our rules, that, you know, we have a duty to the community at large to say, hey, we need to deal with this. And it doesn't mean you have a conflict of interest or there's a boogeyman out there of any kind. It's just practical governance, or so to speak.
It's not pointed at you personally, so just, you have to think again ahead to a different set of people. So it's hypothetical who's going to be
Like I
living
said,
there
I
5 or 10
I think
or 20
most of the
years.
boards are gonna operate in good faith, and I think that has to be the standard. And if it becomes a problem, it becomes a problem, but I think if you try to allow for every potential contingency, we would have, our government documents would be this thick. And it's just not practical.
Are you voting on the a proposed amendment right now, or you're just rejecting it out of hand?
Well, there hasn't been, you don't propose amendments.
Right, I'm asking if you would consider amending it to make it an equal requirement that all complaints are in writing, so we have documentation, not that anybody's got a bias in filing the complaint, just
So,
that.
again, we're here to hear your comments,
Good.
and then, once comments are put forward, the board will discuss what we do.
Well, I think that's an important one for this policy. For public safety and health, you're not defining what that would be. So, do you have any examples of what, in a single-family home community, what would be urgent? I'm familiar with what happened in the stakeholding process around this, but we don't have those conditions. We're not in a high-rise building where pipes can affect a neighbor below, gas leaks in the same manner. What would rise to that occasion that would create the 72-hour cure period versus a 30-day cure period? Can you think of any example?
I can think of one. Let's say a neighbor goes in his backyard and starts burning hazardous materials in his backyard.
Okay.
I mean, the list could be endless.
Okay. So, but
Conceivably.
your policy then says that the notice is sent via certified mail. So the fire's occurring today, there's hazardous materials, so you're gonna go to the mailbox, or you're gonna go to the post office
No,
and send
I'd
certified
probably
mail.
go to the sheriff's department and call the fire department, do that first, and then we'd probably send a notice out to the homeowner that, hey, don't do this anymore.
Okay.
I mean, there's some practical aspects. We cannot cover every contingency. It's impossible to do. You know, it just is. I mean, that's why laws change. Every year the legislature meets because they come up with new scenarios, new contingencies, you know, new dynamics. And we're just a homeowners association. My God, we just don't have the resources to create a manual, you know, that's 1,000 pages long to deal with these things. We're just gonna do the best we can. We're gonna operate in good faith. I mean, that's all we can do.
Well, the purpose of 1137 was to give people time to cure a violation, 30 days typically. And so the concern would be that the 72-hour notice period would be applied to things like, well, there's a dandelion, and somebody could be allergic to the dandelion, so we're gonna shorten that to.
Well, that takes it to the extreme.
You have to use
end.
common sense.
Yeah.
Right.
And not, you know, take the,
Well, in 2018, we were only giving people 3 and 4 days before threatening them with fines, so we were doing it on that short time period.
But that was
for
then
typical.
and this is now.
Okay, so we're not intending to go back to that and finding a way to turn those into health and safety. Okay, great.
Any further homeowner comments?
The impartial fact-finding process, in 2 different areas, you're defining how the impartial fact-finding would occur before you send a notice. Certainly, you wouldn't send a notice if there's no factual evidence to support the actual violation. You'd have at least one fact, a picture, something in writing, something that says for sure there's a violation. You wouldn't just send the notice first and see if the facts then come up later, right?
like I said, I think we're gonna operate in good faith. And I think that's the standard that's,
Well, the standard is impartial fact-finding required by Kiowa's, that's actually,
and we're gonna apply those regulations
it
in
doesn't
good
say
faith.
good faith. But it doesn't say anything about good faith, it just says
Well,
a
I think that's
process.
implied.
Okay, that's an opinion. But in another area, you're talking about, and this is part of the written policy, that the impartial fact-finding will occur only if a hearing occurs. So that reverses the flow, so by the time you've sent the notice, the person then says, well, I don't think that I've actually done anything wrong, requests a hearing, and then you'll do the fact-finding later? Because that's what you're putting in writing, and that has nothing to do with
confusing the
1137.
issue.
John?
The policy does actually say that on the initial, there's an initial determination where the board has to determine whether there's sufficient evidence.
Right.
So, we don't just send them the notice out without considering the facts and considering whether there's sufficient cause to do so.
But the language doesn't say impartial fact-finding. Could that maybe be something you could consider there, so that that's clear?
Yeah.
That's not just reliant upon the individuals having good faith. That's the point.
The board will strive to act impartially, I believe.
How do you know somebody 5 years from now will do that, though? That's
But
the
we're
kind of
talking
the
about the
point.
current board putting these policies on the table, we're not talking about what policies a future board might adopt.
So the
And
section,
if it
the
becomes a
section.
problem, you remedy it. I mean, that's how it works.
Okay, so-
That's how law works.
So the section that says the impartial fact-finding occurs only if a hearing occurs. That seems to cause confusion.
Well, let me try,
So-
let me try to clear this up, this legally. If you were to assault a neighbor, the neighbor would go down to the local magistrate, and the magistrate would listen to your story, and he'd make a determination whether there exists to be probable cause to arrest you for assault. The fact-finding comes at the trial. Okay, the magistrate doesn't do the fact-finding, he just sees if there's probable cause that this may have occurred or that there's an issue. And then it moves to the fact-finding, which is what a jury does. Same sort of concept here, we get a complaint, the board meets, is there a reasonable cause to believe that something's happened? Yes. Then we would send out a letter, and then if there's a hearing, there would be a fact-finding of whether it rose to the level of a violation.
So for instance, if somebody said, well, I think that somebody had a loud party disturbing the peace,
Right.
okay? So you would actually put them through the process without having got a recording or
Not
anything
necessarily.
else?
You're making an assumption there that is not,
I'm not making an assumption.
yeah, you are.
Okay,
You just
hold
did.
it.
I'm not here to debate. I'm just simply saying, we're not in a magistrate,
Okay.
this isn't criminal court,
We're not
Okay.
here
and nobody's
to
assaulted
debate.
anybody.
So let's move on.
Okay. So the comment is, you have two things talking about impartial fact-finding. One of them says it occurs after the hearing. The other says that it will occur, and it seems best, even though the wording is different, that something is done prior to sending out the notice, that some facts are actually verified.
Okay, board discussion. We have a motion on the floor to approve the policy, covenant enforcement procedure policy. Discussion.
I looked at the comments that we received, and I picked up three things which I think we can easily address with simple changes to these policies before we sign them and adopt them. And the first of them is in Article 2, number 2, which is what we've just been talking about, the initial determination. I think if we add the word promptly before shall take the following action, so we say shall promptly take the following action, then it's consistent with elsewhere in the policy where we use that word. Second thing is in Article 6, number 2, there's the words 1 calendar year, which I believe is confusing. Most people would understand the calendar year being from January the 1st to December the 31st. I suggest we change that to 12 months, just to be clear. That happens in 3 places. And then the last one for this is Article 6, number 4. This is where we're talking about other things we can do, enforcement actions other than fines, I think where it says the following action as the board team deems appropriate, would be clearer if it said the board of directors deems appropriate. And that would make it clear that it's not, the committees are not authorised to take these actions. I think we could change that wording when we get back from this meeting tonight or tomorrow. We can sign amended versions.
Comment?
I'm kind of of the opinion that this was prepared by lawyers who are more expert in drafting a document that conforms with the law. I don't know if any of our changes would in fact conform with the law, because that was the intent of this, to conform with the law.
Right. Well, as far as the word promptly goes, then that is used elsewhere, so it seems reasonable to use it again here. As far as 1 calendar year goes, then I've searched Kiowa, I've searched the House Bill, I've searched all the other statutes I could get my hands on, our declarations and our bylaws, and I can't find the word calendar. I searched for year, there's 36 uses of year in Kiowa, and none of them have calendar in front of them. So I think that's a genuine oversight, and for clarification, 12 months serves the purpose.
Isn't this kind of just semantic?
No, it's not, because it's talking about more than one violation. So it does depend on the way it's written, whether that first violation happens in January or December. So
I think that the common usage, when someone refers to a calendar year, they're talking a full year from the date of a violation or from any event.
that would be a year.
I mean,
No.
I mean, basically 12 months is not a good, we should really designate it 365 days,
Yeah.
plus or minus a leap year. I mean, you know, if you want to get specific. It seems to be semantic to me.
Well, it
And
doesn't to me.
I tend to like the idea of going with a lawyer drafted, that's what we paid him for.
So I think it would cause confusion the way it's written, and we can easily resolve that.
Any further discussion? Well, the motion on the floor is still to approve the policy.
So I'm proposing with these changes, do you want me to make a motion for that?
The motion on the floor is to approve the policy as it is written. Any amendments have to be, any changes have to be, a motion has to be made and has to be voted on.
Yeah.
So,
can I make a subsequent motion to make these changes?
we have to do them one at a time.
That-
One change at a time.
But
Each-
one of each of the, yeah, okay, make a
Yes.
motion to add the word promptly in that place.
All in favor? Opposed?
I make a motion to change 1 calendar year to 12 months.
All in favor? All opposed?
I make a motion to add the word of directors after board, as indicated.
All in favor? Opposed? So, the, motion to approve the covenant enforcement procedure policy as currently written. All in favor? Opposed? That brings us to our next policy, alternative dispute resolution. There are homeowner comments?
Yeah, I'm out of here. I can't stand your ineptness.
Well, thank you, I'm
Thanks for
so
being so
happy.
rude.
Any homeowner comments? Pardon? Where are you? Alternative dispute resolution policy?
Do you
Yeah.
have to vote, Laura, when they vote? I
So,
was gonna,
I vote in the case of a tie or to force a tie.
oh, so you could have voted with John, and that would have been a tie, but we only have 4 directors.
So I have been, unless there's been a tie, I
Okay.
have not been voting. Andy, did you have your hand up?
I did.
Okay.
So in section 2, you have the phrase "other similar charges." And
What page are you on, Andy?
I don't have a copy of the full policy, so this is under Article 1, Alternative Dispute Resolution Policy, your numerical 2 on page 12. So other similar charges should not be fines or interest or legal fees for compliance with 1137. In other words, there was a specific purpose for segregating actual assessments, which are the monthly fees, from other things, any other things. And so when you're using that phrase, other similar charges, it becomes a vehicle for transforming fines, interest, and legal fees into individual assessments. And then that would be excluded from ADR as a topic. So for instance, if those types of charges are applied, you should have a right to raise that issue and have that dispute resolved. The purpose here was so that that shouldn't happen, but if it does, you should have the right to raise that issue through that ADR process. I think the key here is that if you exclude those types of things, you're allowing a dispute to then escalate. And that's really the purpose of ADR, is to avoid escalation, including up to litigation. So you want people to go into ADR.
So
don't
the
you?
alternative, first of all, we are encouraged, but not mandated.
Correct.
Anything that has to do with covenant enforcement comes under the covenant enforcement policy.
What about, but what we're not specifically talking about here, and a more robust ADR program would be also addressing when the board itself violates the governing documents. There's really nothing in this suite of policies that addresses, well, what's a homeowner supposed to do to raise that properly? A violation of the rules is a violation of the rules, or a violation of the governing documents, even if the party doing so is on the board. So to resolve those disputes, it's in the best interest of the whole community to have access to an ADR process, which includes just informal negotiation. It includes mediation. But the purpose here is to avoid anything going all the way to the point of litigation, not just shutting people down and saying, yeah, we're not gonna deal with that. So why not specify what the right way is to address violations by the board if the board doesn't do something properly?
Well, I think the homeowners always have the ability to call a special meeting and deal with that, any violations that the board may have committed. I think,
Which requires a quorum, right?
yes.
Right. So if an individual can't find 8 other people that want to stick their neck out,
Well, then maybe the violation isn't so great that.
Or maybe the
it is
retaliation's
worthy- It is
been great.
worthy of a special meeting. If you can't find 8 people, then, you know,
Really?
maybe you're nitpicking.
Yeah, yeah.
Okay?
John?
Here I'm happy to go with Walker's point of view that this is what the lawyer gave us, and we would be going into uncertain waters if we try to change this.
Well, it just begs the question, and perhaps this is why we continue with the legislators to talk about, there's a resistance to putting anything in governing documents that says, well, how do we have oversight over the board? And it's not nitpicking, it's if there's a black and white violation, let's say for instance, somebody resigns and then you decide to have a vote anyways, and you're not following the bylaws. What's the process for dealing with that?
If legislators are looking into it, then they're the best people to do it, not us.
Right, but the attorneys, the ones who are writing these documents, are the ones that are lobbying against any changes because, well, that's not in their interest
So
because they
Now you
can't
get into
profit from it.
speculation, yeah.
Let's-
Yeah.
It's true,
So-
so we're not going to define how homeowners who have the responsibility of oversight, if the board isn't doing something right, there isn't a requirement, a quorum requirement at all. If a homeowner as an individual finds something incorrect, they have a path that is not required for them to find 8 other people, and that doesn't automatically make it nitpicking.
Well, I would think that that would open the whole ADR process to abuse by a homeowner who just wishes, for lack of a better word, to raise hell with the board, and in his or her mind thinks the board is violating something when they're not, and it hasn't risen to that an egregious level that he can't find, or she can't find 8 other homeowners to join in a petition to address it in a homeowners meeting.
Well,
So
it
that
isn't-
is your avenue, and I think it is also, that avenue is also a guardrail, so we don't get involved with homeowners over every little thing or perceived wrong that the board may or may not be doing.
Well, if you don't follow the bylaw, that's just simple fact.
So we've
But that
noted
said, you
your-
can always go to court over
We've
that,
noted-
as an individual.
We've noted your comment. Do you have others?
So just on that point, small claims court is currently open for review of whether or not the board is following the law. The
So,
point is ADR should avoid that outcome. The small claims court is a low dollar
Andy, do
thing.
you have other comments?
We're on ADR, so that's the main comment there. So with that said, I would just like you to consider defining a path in ADR for those situations, because they do occur, and they occur frequently in HOAs across Colorado.
Yes.
I would have to say, listening to Andy there, if one person could do that, go to the board and say, you guys are out of control or whatever, that one person could tie up the board all the time. I mean, I think that's happened in the past, and I think, if you can't get a quorum to do it, an individual shouldn't be able to.
Any further comments? Comments from the board, discussion from the board?
I'm happy with what the policy's drafted. For the attorney.
Was there a motion to approve this policy? Walker just.
Yeah, I make a motion to approve the policy.
Further discussion? All right, all in favor of approving this policy as written? Our next, policy is the procedures for adoption and amendment of policies, procedures, and rules. Open for homeowner comments. All right. Wait, we need a motion to, I'm sorry, I jumped.
You
again.
have, you have
We
a, you have a
motion
typo,
to-
you have a typo on page
We
14.
have a motion to, approve the policy.
Yes, so we did that.
Oh, did we?
Yeah.
I apologize.
There's a typo.
There's a typo on page 14, proposed is incorrectly spelled.
Good catch.
Further comments? Okay, board discussion.
I'm happy with it.
All right, all those in favor of approving the policy? Our fourth policy is the collection policy. Is there a motion on that policy?
I make a motion we adopt it.
Are there comments from the
I have a
homeowners?
question,
Yeah,
in the collection policy, for the fees, is, maybe I skipped over, but can you pay it all at once like for an annual lump sum, or you have to do it monthly?
No, you can.
Well, you can pay it annually, yeah.
Yeah. In fact, what about a third of the people in the HOA do?
Yeah, well,
Do it
that's what we
annually.
did, I saw it, but I see here, it says period on a monthly basis, tell the owners, I see reference to the monthly, are due on or before the 21st day of each month. That's the, in number one.
That's the kind of the minimum.
Yeah, well, just so long as it's not, in your reading, it's not excluding being able to
No,
pay.
no.
And I'm not gonna, you know, I wouldn't want to see you have to do it every month, I
No.
would pay it one time. Jeez.
No, money early is better than money late, though.
Yeah.
further comments? Yes, Andrew?
So the first one is, the language that you've got is new about the due date. And I'm not sure if I completely understand it, but the invoice goes out on the 1st, is that correct?
Correct,
And then it's due on the 21st.
correct.
There's a second part there that I think could be worded better, and maybe you've considered this since my comments, about 15 days past due becomes delinquent. So you have a due date, and then you have another interval, 15 days after the 21st. So you're gonna apply a late fee on the 21st.
No, that's not what it says.
That's the point. It's a little unclear when the late fee is applied, after that second interval?
Well, this was designed to basically mimic what QuickBooks is now set up for. Because we get the first notice on the 1st, and then a late notice or reminder notice comes out on the 22nd.
Then I think something making clear when the late fee applies
Well, it
would
does,
help.
if the full amount of any past due assessment is not received within 15 days of the due date, and the due date was the 21st.
I think the due date in some people's minds might be, well, isn't it just due on the 1st when you send the invoice?
Well,
And so,
yeah,
you know,
but-
that's, it could be worded better. That's my comment.
Well, I've got, assessments are due on or before the 21st. I thought that was clear enough that it's like, okay, 21st is the date that it's due, and then 15 days after that.
How many times do you wanna have the conversation with different people? Again, 5 years from now, 10 years from now, you can be worded better.
I'm not.
And this isn't
in
required by the
practice-
attorney to comply with any law.
In practice, everybody is prompt, and we have misunderstandings occasionally.
But this is a-
Checks don't arrive
I'm sorry.
occasionally, but this is,
My comment is that it could be worded better, and I don't think this came from the attorney, and I don't think this is part of the law. This is something that we added to there based upon what QuickBooks does. It could be worded better. That's my comment there. $100 a month late fee when the underlying assessment is less sounds high, and I recognize and acknowledge it says up to. It seems to make sense that late fees should just simply be an amount, and prior to this, we had collected up to a few years ago annual assessments, and $100 was the total late fee if you paid late. And so I don't buy into the concept that there could be costs and that we're covering potential costs, because elsewhere in this policy, you're talking about pass-through costs, so that any cost you actually have, you already have the power to send them on to the homeowner. Multiple clauses actually refer to that. So the late fee should just be a fraction of the amount due. This allows, if somebody's in financial distress, this actually can create a bill far greater, and it can accelerate the timeline before you file a lien and take legal action heading towards foreclosure. Because it's discretionary, that means that you could, if you wanted to accelerate getting to foreclosure, you could just do the highest $100 amount and get there in 3 months. And it really should be about 6 months of back, unpaid before you get into that legal action. That was the intent of 1137. Is it possible to just simply have a late fee of, let's say, $5 to $10 a month and collect your other costs as you have the right to elsewhere?
the problem with $5 or $10 a month is, doesn't incite any fear whatsoever. And $100 incites fear.
You're intending to terrorize people?
Well, you want it to be a concern of people. If you put it at 5 or 10, there might be some sliding.
I don't think Kiowa in any sense wants to incite fear.
I think the $100 is discretionary to the board, and once again, I think the board, in all cases, will generally act in good faith, and I don't think this has been a problem in the past, and I don't anticipate it being a problem in the future. And if it does become an issue with homeowners, I think they can be addressed then, but I think you want to give the board the flexibility to assess each instance as the dynamics and the facts apply, and we should not be hamstrung in that regard.
So far, we've had no problems at
Well,
all.
John?
And everybody is, to be in this subdivision, it would be unusual that $100 is an onerous amount of money.
John?
I think the per month is the issue, and this is a carryover from when the previous policy used to say that that was based on the assessments being paid yearly. So I think if we just change instead of per month to per year, then we're back to where we were, and there isn't that concern anymore about $100 a month being applied.
Part of the purpose of 1137 was to not, and the term that we use in stakeholding is financial menacing, which is to terrorize people with high costs. We're gonna hit you with $20,000 of legal fees. We're gonna take away your home. That's why 1137 was passed. And that was happening across the state with numbers that are now just published on March 11th. So the point here, is that if somebody's having an actual financial problem, and I understand the value of homes makes you think that people aren't going to age, become on fixed incomes, have high medical expenses, or have any other financial stress, and you're gonna terrorize these people by increasing the cost and breaking them?
Those are
I-
your
what-
words,
what-
Andy.
what- how does that help?
We're not terrorizing anybody here. This policy has been that $100
I didn't bring it up.
has been in place for over 15 years.
Right.
And given the cost of inflation, I think it's pretty much a de minimis cost, and I don't think it's gonna rise.
No other
But
business-
I think the board will use its discretion and good faith in applying it to any homeowner here, and take into consideration any circumstances that comes to their attention.
Yeah.
And they've done that in the past, so.
I'm still making my
I think
comment.
it's a much ado about that.
And to finish my comment, the interest rate was lowered because that was a predatory practice from 18% to 8%. And there's really no good examples out there where somebody for paying a $56 bill late would pay more than that. There's really not a good example. In most cases, it's fractional to the original amount due. So the purpose of this was not to, oh, well, we're gonna lose out on some interest and now we're gonna make it up over here in late fees. The purpose of an HOA is not to turn a profit. It is a nonprofit organization. And it's not a pass-through cost.
So Andy,
Collect
what
the
is your
cost.
point, and then move on?
It's too high and it should be proportional to what it was, which is a fraction of the annual amount. An annual cap would make sense. A flat amount per month would make sense. I don't see a need for that because you can collect any actual costs that are there. It should not be used as leverage.
So, okay, what's your next point? Did you have one, please? Next comment?
That's my comment.
Any other comments? All right, open for board discussion.
As I said, I do think this would make more sense to set per year rather than per month. That's what's
So,
the original
so
intention.
you would be at essentially $8 a month.
No, I would say $20 to $25 a month, and then when you hit the cap, then
But per month?
Why don't we just leave it up to the discretion if it ever arises? I mean, I think we're all gonna operate in good conscience on this. I mean,
See,
I
there's no
understand that.
intent whatsoever to fine somebody if there is something that goes awry, a check that goes awry, and we've had them.
There's
People have had to
return, yeah.
cancel checks, and, it's.
Well, there is a separate charge for return checks, isn't there?
No, it's not a return check, it just never
Wow.
showed up.
never showed up.
Because banks make mistakes, and they send it to the wrong address.
I mean, the mail service makes
And
mistakes.
the mail service is late, and generally, people will communicate with you,
I think.
but then there's
They should get a little scale.
there's concern that there is a late fee, but so far, we've never had, you almost have to have an intention to be late, and it's never.
So more than
1137 arose because of automatic payments.
Homeowner comments are over.
So more than one of the people that sent in comments raised this issue. So I think we, just by changing that one word, we can, satisfy them that this isn't a case of we're out to get you. Which is.
I don't think we're out to get you, but I
No, but that's what's perceived.
recognize that inflation has caused costs to go up. And I don't think $100 a year cap is in keeping with inflation, that's my opinion.
$200 then.
Well, I mean, you made the statement that you thought $25 and whatnot, but if you have a scofflaw who does this every other month,
Yeah.
then you're up to
$200.
$150.
But, and again,
Leave it to the
it's,
discretion of the board as to how
right,
they wanna handle the issue.
it's not something we've had to deal
It's
with.
not a burning issue, and if it needs to be changed in the future, it can be changed.
I can see where it came, because most homeowner fees are so much higher than $55.66. I've talked to people in the hundreds of dollars, and I can see that in those cases, $100 is still.
There's another.
By the same token, what if our homeowners' dues, 5 years from now are $1,500?
Yeah.
then, you know,
Then we'd have to change
then you have to
policy
change
again.
it, so
Yeah.
just leave it at the discretion of the board.
There's another consideration here that, of course, you know, all these governing documents are given to potential buyer of a house in their neighbourhood. So would not some people be put off by this thought that they might be
Charged
$100 a
$100
month
if they didn't.
if they were, for whatever reason, late in paying their
I don't think
assessment?
that would put anybody off, didn't put anybody that we know that bought maybe here off, and that was the policy beforehand, so.
Yeah.
It's just a matter of perception, you see, that's what I'm driving at, that we could easily diffuse.
I thought 100 was kind of a good, you know, it's like, yes, you pay attention to it, but on the other hand, it's just $100.
Further discussion? All right, then, we will take the vote on the collection policy. All in favor of the policy as written? Opposed? Then our last is the conduct of meeting policy. Homeowner comments? Andy?
So, we've discussed ad infinitum, how to, come up with the agenda, and, making it the sole domain of the president, I think is a very bad idea, particularly locking, other board members out from being able to bring items to the agenda, which is what happened when I served, twice,
So,
3 times actually.
in response to your comment, the Nonprofit Act is clear that the board sets the agenda.
Mhm.
And this simply says the board through the president.
Mhm.
It does not make the agenda the sole purview of the president.
But you've made a good point of, this has never happened, and I'm pointing out, this regularly happened. When you don't like certain people bringing up certain topics, you shut them out.
That is
And-
actually incorrect in that was, while you always said it was my decision.
I'm just making my comments. I'm not here for a
And I'm
debate.
answering. You always said it was my decision, it was always a board decision, and you didn't like it because you didn't get your way.
No, I didn't like it because we waited 10 months to pass these policies and it held up being able to do any enforcement until now. Or let
That's
the weeds grow to
actually
5 feet tall,
incorrect.
or et cetera. These are my
So
comments.
let's go with, what is, any
So those are my
further
comments.
comment
Now,
on
yes,
the
I'm
meeting
continuing on
policy?
because I got interrupted. So the section on voting. You are now calling for a quorum of 20%, where throughout our documents, the quorum is 10% elsewhere. And I'm wondering why we have a different quorum just in one section. That's gonna stick out a little bit. Third comment is regarding audio and video recordings. And fourth comment, I think, audio and video recordings, there's been several attempts to stop them. There's no law against that in Colorado. And there's been no example of them ever being used in an edited fashion. In fact, it actually protects people from situations where there's a debate over what actually occurred. It's an objective record. But there's a step going farther here where the association now, per this policy, seems to be wanting to call police and create criminal charges, not only for things like recording meetings, but even for speaking out of turn. And I checked with the Larimer County Sheriffs and the City of Fort Collins, and the problem is there's not actually a law that a law enforcement officer could enforce upon being called for disruption. So, and it actually raises the issue of if you know that there's no actual law to be enforced and you call the police, that itself is a violation of criminal code. If you know that. The requirements for things like disorderly conduct or harassment require proof of intent, require it to be a public place. And in spite of the ownership of this building being the City of Fort Collins, this is a nonprofit corporation having a private meeting. Not anybody from the general public can come in, so this isn't even meeting the basic requirements in the exceptive case where you might be able to have the police apply a law. They're never gonna know intent, and if you simultaneously subject people to a situation where they can't defend themselves with a recording of themselves, it just seems like this is a way to stifle dissent when you don't like what other people are saying. So I think it would actually be the best approach, like we did in 2019, where a recording of the meeting was done by the secretary and then held by the association in the records permanently, not deleted, because it has value enduring. If there's ever a dispute, that's a good thing, not a bad thing that there's an objective record. And that any homeowner that wants access to that recording should have it on demand and shouldn't have to get a subpoena, as we have in some emails, that things aren't gonna be released unless there's a subpoena. If there's a concern over a homeowner having a recording and how it can be used, the best solution to that is to simply record meetings like any other governmental or quasi-governmental agency does. It's not only helpful for making sure that the meeting minutes are accurate, for any secretary that's taking notes, being able to go back and say, what was the actual language we used for that amendment, is very helpful. So again, to reduce disputes. So I'll just say, I went to one of my neighbors who's unable to attend and isn't allowed to participate via Zoom, because we've disbanded that.
Call in.
But we're not really making it easy with the available technology for people to participate who can't be at these in-person meetings.
Everyone's not.
And I'm still in the middle of my comment. And so I think that the comment from that homeowner was, this is tyrannical. His comment, I'm passing that along since he can't be here. Tyrannical. I've heard other comments from other homeowners, draconian, authoritarian. What in the world is this about? I mean, if you don't already have existing powers, and I would put it this way, you're giving yourself with these new powers. I'm sorry, I'd just like to finish my comment, and then you have the floor and you can do all the comments you like. If you simply use the powers that you're already giving yourself, such as you're right now creating powers to take away voting rights, okay? You have the power to enforce rules and give out fines. Why is it that you need the explicit policy to call the police? What's that about?
Well, I think a perfect example is, let's say I stood up and just shouting obscenities and just throwing papers in the air.
Mm-hmm.
Okay? What are you gonna do about that, Andy?
Watch and take a video of it?
Okay?
So,
The point is, we're trying to conduct a meeting.
Mm-hmm.
And if we can't.
Has anybody ever done that?
Let me finish, please. If we can't conduct a meeting because someone is being so disruptive,
Mm-hmm.
then we have to adjourn the meeting. Okay? And then we have another meeting, and that same person keeps doing that. There has to be a remedy for that.
You can fine them, right? You can say that they're violating the policy and you can apply a fine. What law is a law enforcement
Finish
officer?
my statement, Andy.
Okay.
Okay? You don't like when people interrupt you, you're interrupting me.
what's your point?
The point is, we're trying to conduct business.
Mhm.
And if someone is being disruptive and they need to be removed so we can conduct business, then we call the police.
And what law are they going to enforce?
That is. for
Leave that up to them.
That is up to them. Now, do you
so-
have further comments? on
Yes,
this?
yes, there is no law, that's the point.
That
you
is
have-
That's your
not,
opinion.
you've already, hold.
That's not my
hold-
opinion.
Hold it,
I literally,
hold it.
you asked if I had another comment, and
Do
I
you
did.
have any further comments on the meeting policy? We've already heard your comment about whether or not section 5 is appropriate.
I'm responding to the comment that it is just my
This
opinion.
is
I did the
not-
legwork, and according to the city of Fort Collins Police and Larimer County, there is no
That's
statute to be enforced, and they don't appreciate being done that way. And this is a new comment, in the legislature, you have law enforcement begging legislators to not have their resources tied up with these types of things. If you need a sergeant of arms, get a sergeant of arms privately because you're a private corporation. You don't have access, you're not an actual government agency that gets to use the police at the door.
And that is your
You're
opinion, we
using,
have
you're
duly
using
noted.
public
So-
resources and trying to intimidate people, which you've already talked about, by saying you're gonna call the police, but there's nothing for them to do, and that itself, when you know it, is against the law. That's my comment.
Jeff?
I appreciate the comments, I appreciate the board's action, I just wanna note a few things. Thank you for your service. This is a volunteer board, doing the best they can, they lead full and active lives. And this is a drain. HOA law in Colorado is in turmoil, as the legislature demonstrates by repeatedly revisiting HOA law. So it's in flux, so you do the best you can to respond in a timely and cost-effective manner. The issue of maintaining order at these meetings has come into play. I've heard that people have felt threatened to leaving these meetings by attacks. The board has made decisions before that people have failed to follow, which has necessitated action. So the board can have a sergeant of arms to remove somebody or hold order. I don't know what kind of liability those people would face. It's not a good time to be wading into that in a private capacity. So I think the board did the best they could. They sought legal advice to interpret some very convoluted and conflicting legislation. Appreciate that. Appreciate the due diligence that the homeowners have put into reviewing these documents. Appreciate Andy finding a typo. As someone that types these type of documents, that's one of my big fears, is to have an egregious typo stick out. So thank you, and I also appreciate the history this board has had of discretion, as it was put up. I remember one of our HOA meetings, years back, where we talked about, could people contribute to a fund to help people out that had some kind of financial difficulty?
Yep.
We used to talk about those types of things, and somehow it's gotten lost over the years. It's not this board, it's several years back. So appreciate the homeowners for reading all this stuff and having thoughtful comments. I'm sorry that some people felt obliged to leave and make comments on the way out the door. This is the way HOAs work. So thank you to the board, thank you to the homeowners here and at home.
Further comments? All right, board discussion.
Do we have a motion to adopt it?
Make a motion.
Discussion?
I agree with the comments about using the word through the president. And again, you know, it's perception here. I think it would be much better if it said through the secretary. I see putting up the agenda as an administrative task that is spelled out in Robert's rules as a job for the secretary to do.
It also says in Robert's rules that the presiding officer, with help from the secretary in another's place.
That's my opinion.
Any further comments, discussion? All right, all in favor of the conduct of meeting policy as written? Opposed? That concludes our business. We